Hi, everyone. This is Jackie Gadapour-Werns from Thompson and Horton, coming to you from sunny Dallas, Texas. And I'm here to give you the Title IX tips that you need to know about the recent appeal of the decision in Victims' Rights Law Center versus Cardona. So, what are the three things that you really need to know about this decision? One, this decision deals with a clause from the 2020 Title IX regulations that said that if a party or witness didn't show up to a hearing in a Title IX process, that the decision maker couldn't consider any statement that that party or witness had made outside of the hearing context. So, what that means is that even if a respondent, the alleged perpetrator in a Title IX sexual harassment case, admitted to 50 people outside of the hearing that they had engaged in sexual harassment. If, knowing that this rule existed, they decided not to show up to the hearing, the decision maker could not consider those out of hearing statements. Two, in July, a Massachusetts federal court declared that this provision was arbitrary and capricious, and it wiped it from the face of the earth. Okay, it didn't really. It vacated it, but that's what it essentially is in the exciting world of administrative law. So OCR then came out and said, you know what? We're not going to enforce this provision of the 2020 Title IX regulations. And so schools started, understandably, removing it from their Title IX grievance processes. Three, what's happening now? Three male students from higher education institutions who have been accused of sexual misconduct have joined with my new great state, home state of Texas, to sue to ask the court if they can appeal the decision from Massachusetts. And so they've recently been allowed, apparently, from the First Circuit Court of Appeals up in the Northeast to join in and to challenge the decision of the trial court, because their reasoning is the Biden administration isn't going to show up to defend this Trump era rule, and so they should be allowed to do so because the rule affects them. So what do you do with this? What do higher education institutions do? Can you change your rule? When should you change it? And what about K-12 schools? You hear a lot that this doesn't apply to them at all, but is that really true? Mosey on over to our new blog at www.title9tips.com to find out the answers to these questions and many other things about this important case.